Doing really well. Looks like we've got the Rules Committee will come to order. We're here for the consideration of two measures. First, the Jobs and Energy Permitting Act of 2012. From the Energy and Commerce Committee, we're very happy to welcome the subcommittee chairman, Mr. Whitfield, and Mr. Rush is here. Very timely, the ranking member. Gentlemen, congratulations on your work product here. We know that job creation is what this is all about, and so we welcome your testimony. Any prepared remarks that you have will appear in the record in their entirety, and we welcome your summary. Chairman Whitfield.
Well, thank you very much, Chairman Dreyer and Ranking Member Slaughter and other members of the Rules Committee. I appreciate the opportunity to be here today and talk about H.R. 2021. President Obama, I might say, specifically mentioned the vast potential in Alaska's offshore areas in his May 14th weekly address, and he even highlighted the need for improved process at the federal level as it relates to permits for exploration. For 5 years, red tape at the EPA has prevented leaseholders in Alaska's Arctic seas, particularly the Beaufort and Chukchi seas, from obtaining exploratory permits from EPA. It wouldn't be so bad if after 5 years EPA would make a final decision, because then we could say the administrative procedures have been exhausted and parties could go to federal court to have the matter taken care of. But because of the Environmental Appeals Board at EPA, these processes are never being finally decided. And I might remind everyone on this committee that the Environmental Appeals Board was never set out in the statute of the Clean Air Act. It was a decision made by EPA through a regulation. But this bill is very simple. It simply corrects the endless bureaucratic loop created by the Environmental Appeals Board's existence and environmental extremist abuse of the Clean Air Act for offshore exploratory permits only. It simply removes EAB from the exploration permit process, requires EPA to reach a decision on exploration permits within 6 months, and it makes a few clarifying issues relating to service ships, that they be treated not as stationary sources but as non-stationary sources. So I think that this measure goes a long way in trying to attain our goal of creating more jobs in America, creating more domestic resources in America, and I'm delighted to be here today and urge the Rules Committee to pass a rule to get this bill to the floor.
Thank you very much, Mr. Whitfield. Appreciate it, and thanks for your hard work. Mr. Rush.
Thank you, Mr. Chairman. Mr. Chairman, let me begin by saying we're not at cross purposes in terms of creating jobs for the American people. Let the record reflect that I am not opposed to drilling in Alaska, and I am not opposed to streamlining the permitting process in a sensible and thoughtful manner. But what I do object to is the cutting out of input from the very communities that would be most affected by this process, or preempting states' authority in order to expedite the permitting process for a single company. While this bill will benefit Shell, the repercussions and consequences, both intended and unintended, will have a much greater impact on many different stakeholders. If the majority had been willing to work with our side on this bill, as we offered to do, as we pleaded with them to do, as we encouraged them to do, we would have created a bipartisan piece of legislation that could move through the House and the Senate, and which ultimately would have become law. However, this bill does not take into account some of the very real concerns that the minority has outlined to the other side, to the ranking member and others, on several occasions. And so we must allow an open rule in order to give members of this Congress the opportunity to strengthen this bill when it comes to the floor. This bill is not about creating jobs. It is not about lowering gasoline prices. It is a giveaway to the oil industry that will ultimately increase pollution along our coast. This bill's supporters have said that this is a narrow bill to address problems Shell has faced in obtaining a Clean Air Act permit for exploratory drilling off the coast of Alaska. But this legislation will affect every state on the Atlantic and the Pacific coast. The states of California and Delaware testified that they have grave concerns about the impact of this bill on their ability to protect public health and welfare from pollution. This bill has many flaws that will lead to more pollution and less public participation in the process. There are a number of areas of concern, but let me limit it to, if I have time, sufficient time, to 5. The bill will allow oil and gas companies to look only at their air quality impacts onshore, ignoring how the drilling affects offshore air quality. Many people, such as Alaskan natives who depend on subsistence fishing and whaling, spend a significant amount of time offshore and will be affected by dirtier air. Another concern, this bill will allow oil and gas companies to pollute more by removing the ability of California and other states to regulate the emissions of support vessels, such as supply ships. The bill sets an arbitrary deadline of 6 months for final agency action on every offshore exploratory drilling permit, no matter the size or complexity of the proposed operation. EPA and the states of California and Delaware again have testified that this is not enough time to do a thorough technical review and ensure adequate public comment and participation. The legislation eliminates the Environmental Appeals Board from the permitting process, even though it is a cheaper, it is a faster, and it has more expertise, and it's more of an expert substitute than judicial review. And finally, the bill requires all challenges, I might add, to air permits to be raised before the federal courts of appeals here in Washington, D.C., thousands of miles away from the affected areas, and which could provide an undue burden on less affluent communities. The members of our committee offered a number of amendments to fix these deficiencies with this legislation. Unfortunately, they were all rejected, and I ask that you craft a rule that will allow these members to offer their amendments on the floor in hopes that we can improve this legislation. This bill is about speeding up the process. It's about letting Shell and other oil companies pollute more while cutting concerned citizens, affected states, and other stakeholders out of the process. I yield back to Melissa.
Thank you very much, Mr. Rush. To you and Mr. Whitfield, thanks very much for your very thoughtful testimony. I had no questions other than to say that exactly what you said is the goal that we will have in this committee, to allow for a free-flowing debate on the floor, to allow most all of the issues that are before us to be considered. And I know we have an action-packed meeting this evening. We're going to be going on to the patent bill as soon as we're completed here, so I'm not going to take any time other than to say thank you very much. We'll look forward to a full debate on the floor. Mr. Sessions. Oh, no, you guys don't have to leave. You can't leave until these guys. So thank you very much.
Ed, thanks so much for getting them walking out just before I ask a question. But I'm delighted to see both of you here, my very dear friend, the gentleman, Mr. Rush.
Yes.
Mr. Rush, thank you and welcome for being here. One might ask a question. Why would Republicans say that Democrats, if we follow your statement about Democrats want to help to not only ease the environmental issues, to make it easier for us to effectively utilize our resources? Republicans, say that this president's making it more difficult to obtain our natural resources and gasoline and make it available and to reduce the price of gases. And yet, I looked at this report that was provided by the committee that we are talking about here today, and repeatedly votes that were in the committee push further court intervention. They extend administrative review over the bill. They allow for longer and further public comment periods, not just for a rule that may be coming out, but also final comment. They extend the periods of time. They allow extending to the agency to hold back of anything that may be in here, extending that before it would be implemented an extra 180 days. They allow further state intervention. They allow the most stringent rules that could be enforced in the industry on virtually every form of trying to look for and find energy, rules for vessels that participate in these endeavors. And then you wonder why Republicans say that we're worried about the price of gasoline, that we are worried about the cost that goes into the ability that we have not only to effectively use our natural resources, but to make sure that the cost that's associated with that is not skyrocketing. And so I would just respond back to you today. The only reason we really say this is because it's a prima facie case. It's fact. It's a fact that the Democrats in the Energy and Commerce Committee, not to a person, but in aggregate, it seems like, or looking at the numbers, that your party is trying to, instead of be participatory and allowing effective use of resources, streamlining for jobs in this country, to make sure that people who do choose to participate in this endeavor and to raise money for the government are being blocked, are being, through legislation, stymied in every single way possible, up to and including private companies that have boats and men and women who want jobs, need jobs, not just in the Gulf but all over this country. So I would just say to you, I respect you for saying you don't understand it, but when I look at what the votes are and what the real issues are, I'm delighted that we're going to offer an open rule. I think that's what we ought to aim at, and I wholeheartedly believe that people are entitled to come and offer this. But I'm concerned when people look at us and say, I don't understand why you say we are trying to hinder the marketplace when the answer is intuitively obvious. So I just would offer some words of hope to all of us that if we're really trying to reduce the price of gasoline, which has a huge impact on food prices all across this country, that primarily impacts disabled people, senior citizens, and poor people, that maybe we would look at one of the major causes. That if we're trying to look at our need and desire to effectively get our economy back, and it's our economy, not just gasoline prices, it's not just jobs, it's all these things wrapped together, then we would look at the facts of the case where it's energy prices that are causing our economy to take a hit, not just with GDP, not just with the impact on small business and prices rising, but really America's competitiveness in the world. It comes down to that this administration, the prior leadership that we had in this House of Representatives, and current members of this Congress, despite the horrible economic circumstances that we're in, there continues in Washington, D.C. a drumbeat to make prices higher, to make it less cost-effective, more expensive, and it is placing a burden on the middle class of this country. And the middle class of this country is desperate for jobs. They are desperate to see us work together, and they are desperate for us to effectively not spend our money by having to buy oil from other countries, but rather to effectively use what we've got. So it's my hope that we would find a way in this open rule, this process, for us all to go to the floor, for us gather together and say we need to make sure the middle class of this country, which is being heard by the Republican Party, that we can all be together and do something about this. So I thank you for being. I would yield to the gentleman.
Thank my friend for yielding. We've had 22 amendments submitted to the Rules Committee, and we're hoping that we'll have a structured rule that will allow for an opportunity for the very, very diverse ideas that are out there to be considered, which is what Mr. Rush had asked of us. I thank my friend for yielding.
I thank the gentleman for not only the clarification, but offering me the direction that you think the committee should go. And I would like to thank Mr. Rush and give him the feeling that we can, in this committee, offer the diversity. And I don't know how either one of you would like to respond, Bobby, but I certainly want to give you that chance.
Well, Mr. Chairman, I'm fully aware that you have time consideration. I don't want to spend a lot of time, but I do. My friend, Mr. Sessions, who I often refer to as the Lone Star from the Lone Star State, he knows he's my friend, but we certainly vigorously disagree on this. My district needs jobs. They just started needing jobs. My district needed jobs for the last 20, 25 years. I would not sit here before this committee and advocate anything that would not help provide jobs for the struggling people in my district. I pastor a church, and every Sunday I have parishioners, members of my congregation, who desperately need jobs. I mean, we are in a severe depression in my community. But this bill isn't about job creation. There's no evidence, not a single shred of evidence, nowhere, that this bill will lower gasoline prices by any significant amount in the short term or the long term. Mr. Chairman, Shell told the Energy and Commerce Committee that it won't be able to produce oil from this Arctic operation for at least a decade. For at least a decade. This isn't about job creation. This isn't about the middle class. This is about Shell. Only Shell. All right. And my friend, Mr. Sessions, this bill will not make not one single drop of oil come online, not 1 millisecond faster. It will not do that. It is not about the middle class. It is not about jobs. It is not about the economy. It is not really about energy, except it's about the energy of Shell and the profits of Shell. We don't need to streamline this process and make it more onerous for other states and for other stakeholders. We need to make sure that whatever we do here give other companies, other states, and those same people, the middle class that you're talking about, give those same people an opportunity, all right, to deliberate and have some public comment, because in the long run, a conclusion of this, if we move this too hasty without giving them input, their lives will be even worse than they are today. They will be suffering even more than they are today. Mr. Chairman, I want to thank you for your consideration and making sure that we have an open rule on this bill. And
Well, let me just say, again,
Structured.
if the gentleman would yield.
I would.
I thank my friend for yielding. We want to have a process that allows all the issues to be considered. There were 22 amendments submitted to the committee for consideration. We want to make as many of them clear as possible.
Mr. Chairman, I might just say that we welcome the opportunity to debate these amendments on the floor, because I think it's important that the American people know that even Lisa Jackson in her testimony before the committee said this is not an issue about health. This is not an issue about health. This is an issue that even EPA made a decision to issue these exploratory permits, and EPA's appeal board has tied it up for 5 years. So there's adequate protection here for the environment, and we welcome the opportunity to debate all these amendments on the floor.
Mr. Chairman, I want to thank both these fabulous members for coming forward. Mr. Rush and I are very dear friends. We find much in common with each other, not only on our own successes, but each other's personal commitment to each other.
Yeah.
And I thank the gentleman for accepting my feedback. I accept his, and I thank the gentleman, Chairman Whitfield, for being here. I yield back.
Ms. Slaughter.
Thank you, Mr. Chairman. I'd like unanimous consent to put the administration's policy statement in the record. And let me make just a comment here about what he says, that it would increase federal court litigation, deprive citizens of an important avenue for challenging government action that affects the local public health by requiring them to come to the Court of Appeals for the D.C. Circuit, that they could not litigate anything anywhere except in Washington, D.C., which would be a considerable hardship. This bill will need quite a bit of work on it, if it has any hope whatever of getting signed into legislation. And I will put this into the record. I heard just this weekend the number of permits that have been given this year for offshore drilling. I believe it was something like 48. And I don't have these numbers. I wish I did. We've talked about this before. You may have those. How many acres already of public land has been zoned for drilling where they know there's oil? Does any of your staff have any of that? My recollection is up in the millions, isn't it? I'm not sure if somebody else might know. It's already there that they won't drill on.
Right, yeah.
And we knew 5 years ago when Alaska Drilling came before this committee, we had statements from the oil companies, they don't want to drill up there. They don't know if there's anything up there. There's no big deal about doing that, and they don't plan to. So we just keep flogging this dead horse here all the time. We are producing oil. We have such a lack of refining capacity in the United States, which never gets addressed in any of this, and is one of the reasons I think that we have. But the most egregious for me was the statement about the gas prices. According to Goldman Sachs, we knew this, we did this, we knew this before when we passed the energy bill. Goldman Sachs says 20% of this increase in gas prices is due to speculators. Now, the one agency in the United States government that oversees speculators, the CTFC, had its budget cut in half last week. Now, I was glad to see the Trade Commission is going to take this up. This is good because we need to know this. But we've been trying for 2, maybe 3 years to try to get the speculators out of the oil business. But there's no question, if we really want to do something about gas prices, that's a very easy place for us to start, but we can't do it. There are even complaints, as I understand it now, about having the FTC look at it. Why are we afraid to look at these things? Why can't we get to the bottom of why these gas prices have gone up so high? And why do these agencies that have this oversight suddenly are being told you can't do your work anymore? What are we afraid of? Mr. Rush, what do you think?
Well, I think that the ranking member, you're absolutely right in what you stated so far. We need to have developed the courage and the will to go after the speculators and to go after and discover and do some hearings and really some research and find out exactly what's happening in the gasoline marketplace. I could not agree with you more. Right?
The day this Congress decides to really look into speculation and what's causing these increases is the day I will believe that they're deadly serious about reducing gas prices.
If I could, I just want to just make one thing real clear here, because I think there's a misunderstanding about this 5-year delay.
I do too. They are giving permits right now.
Right. This is very misleading, this so-called 5-year delay. I wrote a letter to the EPA asking for a timeline on Shell's permit application in Alaska. And I learned that Shell itself, it pulled its permit application. The company pulled its own permit application, modified its proposed operation, and changed its target drilling sites on numerous occasions over the last 5 years. They can't blame EPA. They are responsible for the delay. They pulled their own application. And in fact, Shell pulled one of his applications to drill for 2 of the 5 years that's under consideration. And every time Shell changed its plan, the EPA had to adjust its assessment of the potential impacts on air quality and public health. And this is what the EPA should do, all right? And no one should want EPA to take a one-size-fits-all kind of approach to permitting these major sources of potential air pollution. It's Shell's problem. Shell is responsible for the 5-year delay, not the EPA.
Well, thank you. Mr. Chairman, may I get the accurate figures for how much land is already under lease to drill, and also for the number of permits that have been given just this year? I'm asking you if you can hold the record till I can get the accurate number.
Yeah.
Okay, I've got it.
There you go.
If I may use these numbers, I would appreciate it. Thank you.
That's what I was going to tell you.
24 million inactive leases in the Gulf. How do you like that?
Right.
Inactive leases. 22 million offshore leases. I don't have the number of acreage for onshore drilling, but it was pretty staggering. I will get that and put it in. Thank you very much. I appreciate it.
Thank you, Mr. Chairman. I want to thank the chairman and ranking member for being here today. I want to thank them for their good work on this legislation, and I think that whatever we can do to streamline the processes that we have, we should be doing. We should be doing it in all our areas, and particularly in the area of energy, because people are suffering greatly as a result of the high prices of gasoline. And Mr. Rush, we've been hearing for 30 or 40 years, well, it's going to take 10 years before we have anything that comes up. And if we never start it, it'll never be there. So it may take a while, but we need to start somewhere. And last comment, I think this is bureaucracy run amok, and I think most Americans feel that way too. I hear more complaints about the EPA just when I'm out in my district than any other agency in federal government. I'd like to recognize a young man who's here with me today, Mr. Chairman. Alex Hillary, who's from Winston-Salem, North Carolina, is back there in the back. His uncle, Van Hillary, served in the Congress from 1995 to 2002, and Alex is going to be shadowing me this week. So,
Welcome, Alex.
Thank
Good luck
you.
in trying to keep up with Ms. Fox.
Thank you, Mr. I yield back.
Thank you very much. I want to thank you both for coming. I share Mr. Rush's concerns, and I just point out for the record that just because you put jobs in the title of a bill doesn't mean it's creating any jobs. And I would, I think we need to get serious about doing something to help jumpstart this economy and put people back to work. And I think we've done enough pontificating and enough speechifying, and I hope that at some point the leadership of this Congress will get serious and work with us and work with the administration and the Senate to get something passed that will mean something to people in my district. And I don't think this is it, but again, I thank you both for being here. Appreciate your work, and I yield back my time.
I noticed in the committee report you had 5 roll call votes on amendments. I'm assuming that other significant number of other amendments were made that were either accepted, done by voice vote as well.
Correct.
And that the final vote was 34 to 14. Was that a bipartisan vote, Mr. Whitfield?
Yes, it was.
That's my question. Thank you.
Mr. Hastings, I have no question. Mr. Nugent, I have no question. Mr. Scott, Webster, gentlemen, thank you very much for being here. We appreciate it. And now we will hear from the gentleman from Florida, Mr. Hastings.
That I'm offering, and with your permission, I ask unanimous consent to have my full statement made in the record, and I urge support of my amendments, and that's all. I'll answer any questions if anybody wants.
Any questions for Mr. Hastings? Now we'll proceed to Ms. Wilson. Thank you very much for being here. And without objection, welcome to the Rules Committee. This is your first appearance before the Rules Committee.
Yes, it is.
I know, because I remembered your hat. very much. Without objection, I see you have a beautifully prepared statement there. I'll tell you that that will appear in the record in its entirety, and we'd welcome your summary.
Okay, thank you very much. Chairman Dreyer, Ranking Member Slaughter, thank you so much for the opportunity to speak this evening. I won't take up much of your time. I just wanted a chance to describe to you in person what my amendment HR 2021 would do and why I feel it's important. We have passed legislation this Congress dealing with offshore drilling permits and leases and sales in the Gulf of Mexico, and we're here tonight to discuss a new attempt to expedite the energy permitting process. Honestly, I don't agree with many of these attempts, but I hope that you will agree that moving forward does mean we have to leave good policy behind. I am from Florida, which is a peninsula, and so is Congressman Hastings and Congressman Webster. Section 2 of H.R. 2021 limits air quality measurements to legally defined physical spaces called corresponding onshore areas. Unfortunately, this limitation could narrow existing state and local government law that chooses to measure air quality in different ways. These ways do not hamper jobs, and they do not hamper energy permitting. They merely reflect a local area's choice as to how they wish to measure their air quality. My amendment simply would allow state and local governments to do just that. It would allow local governments that have adopted air quality measurements reaching outside corresponding onshore areas to stay in place and continue to operate as they have prior to the drafting of this legislation. In real-world terms, this means localities that wish to measure air pollutants blown into other areas by high winds may. They will not be restricted to measuring just those pollutants found in an arbitrary area mandated by federal law. I hope that you will agree that this is good policy, and if you happen to believe in limited government, I hope that you will join me in respecting the rights of those states and local governments that have already expressed their views on this issue. Thank you.
Thank you very much, Ms. Wilson. I have no questions. Mr. Sessions, I have no questions. Mr. Governor?
I support your amendment. I have no questions.
Thank you.
Fox? Hastings?
Strongly support the amendment, Mr. Chairman.
Bishop? Bowles? No questions. Mr. Nugent? Mr. Scott? Mr. Webster? Thank you very much for being here, Ms. Wilson.
Thank you.
That will conclude the hearing portion for consideration of H.R. 2021. And we will now proceed to consideration of the America Invents Act. And we have the distinguished chairman of the Committee on the Judiciary Committee here.
Mr. Chairman, does Mr. Rush have an amendment?
An amendment to the American Invents Act?
No.
Oh, well, I mean, I thought she'd already testified. I mean, maybe I missed it. Okay, I understand. If you'd like to, I mean, I didn't know that you had wanted to testify further. If you want to say something to the committee, we certainly.
If I could, I just want to testify on the amendment that I do have, and I'll actually
Right.
on the amendments.
Yeah.
Okay. My amendment would simply also allow the EPA administrator to provide an additional 30-day extensions if the administrator determines that such time is necessary to meet the requirements of Section 4, while also providing adequate time for public participation and sufficient involvement by the affected states. That's the essence of my amendment.
Thank you very much, Mr. Scott. Let me just say that I'm intending to encourage the committee to make your amendment in order. So I thank you very much for being here, and sorry if there was any confusion on my part earlier. Thank you very much.
Thank you
So
so
now
very
that
much.
will conclude
But
the hearing
it's-
portion for
but it's
consideration of
Mr. Rush and not
the
Mr.
Jobs and
Scott.
Energy Permitting Act of 2012. And now we will proceed with consideration of the America Invents Act long under consideration, and I want to congratulate you, Chairman Smith, for putting together a near unanimous vote in your committee on what has been an extraordinarily controversial issue. And I know there's still a number of questions out there, and as you and I have already discussed, we're planning to make in order a number of amendments that will allow for virtually every issue to be considered when we move to the floor with this very important measure. So, of course, as always, any prepared statement that you do have will appear in the record without objection in its entirety, and we welcome your summary.
Thank you, Mr. Chairman, and thank you, members, as well, for your interest in this particular piece of legislation. I see this bill, by the way, as generating a number of jobs in this country that is going to stimulate our economy and get the economy back on a good footing. The point of this bill is, quite frankly, to approve better patents more quickly. The situation we face today is that we have a backlog of over 1 million patents that are waiting to be processed. The average wait now to get a patent considered is over 3 years. Clearly, this is not conducive to, as I say, stimulating the economy or good business sense either. The patent system itself has not been updated in almost 60 years. That is to say that we have not had an update since way before the advent of the iPhone or the Internet or any of the other developments that we've enjoyed for the last several decades. So we need to do better. We need to update and modernize our patent law. The intellectual property sector of this country is absolutely essential to our productivity. In this country today, about 5% of all businesses are intellectual property businesses, and that 5% now accounts for 40% of our increase in productivity and half of our exports. So quite frankly, if we're going to have a healthy economy, we have to have a healthy IP sector, and to have a healthy IP sector, we need to modernize our patent laws. The Senate passed a very similar bill, 95-5. We approved this in the Judiciary Committee by a vote of 32-3. Only one Democrat voted against it. Only 2 Republicans voted against it. So I recommend it to you. I have been in touch with the chairman of this committee, and I know that virtually all amendments that are going to want to be offered will be allowed to be offered unless they're duplicitous. And so, Mr. Chairman, if anyone has any questions, I'm happy to try to address them.
Well, thank you very much, Chairman Smith. Again, congratulations, and I don't think any of the amendments are duplicitous, but some may be duplicative. So, for that reason, I think we're going to choose to. I think we're going to choose to make again as many amendments or in order as you and I have discussed. You know, this is a new day, and we want every issue to be considered. And there still is some controversy surrounding this measure, as you know, and we have lots of witnesses who are scheduled to come before us with different proposals. So I have no questions other than to say congratulations, and we look forward to carrying this measure to the floor. Mr. Sessions.
Thank you, Mr. Chairman.
Thank you very much, Chairman. Chairman Smith, I want to thank you for taking time to be here before us today. I agree with Chairman Dreyer. I think this is one of the most, to a member of Congress, complex issues that they may handle. The patent process is a very difficult one. It's one that's not easily understood, but I think that the concepts that you pitched today about the backlog, about the ability that you would have to use the money that would be in the system and given for the system to benefit the system certainly makes sense. I have been in a number of organizations that lived and died off the patents that they made, but when I say that, I mean there are others who perhaps come and take their ideas and move it on to the marketplace. I think it's important for us to remember that patents in different areas, whether it be pharmaceuticals or other processes, have life cycles to them. But I think updating it occasionally every 60 years, given the context of commerce in this country, is the right thing. And I applaud you for taking it on. So I hope that members will be well advised that there will be very important issues that will be debated here and the policy thereupon. And so I want to thank you for appearing for us today.
Thank you, Mr. Sessions.
Thank you, Mr. Smith. Nice to see you today.
Thank you, Mr. Chairman.
It's been
Hello, my friend. How are you?
very interesting jurisdictional debate. I followed that with great attention. There's one issue in the manager's amendment that to my work that it took me 13 years to pass, and that is the patenting of genes. The human genome and that gene research is probably one of the most important steps forward in our lifetime, in history perhaps, medical science. And it's been our firm belief all the way through that patents should not be put on genes, which means that if you have to research on a certain condition that you would have to get permission or pay royalties. So I'm going to have to fight you on that one. But thank you, Mr. Smith.
All right. That provision, by the way, just codifies current law and is not opposed.
Well, the current law is no genes patented.
Yeah.
And I know there's a lawsuit, as you know, right now.
Well, that particular provision was non-controversial in the committee, and I think the outside organizations that have an interest in that particular issue have not opposed it. But
Well, that's not what they're telling me. They're very worried, so that's why I thought I'd mention it to you. Thank you very much.
Let me just say that we're kind of questioning whether Mr. Conyers, if you'd like to offer some comments as we proceed with questions here, please feel free. Without objection, your prepared statement will appear in the record as entirely welcome to summary.
Well, thank you, Chairman Dreyer, and our ranking member and the members of the committee. Unfortunately, I arise in opposition to H.R. 1249, and I understand that reforming the patent system is long overdue, but there are several problems here that are pretty large. And I'd like to point out at the outset that according to the Congressional Budget Office, the manager's amendment would be in violation of the new cut-go rules. And this is something, a new development that I would like to bring to your attention. That's because the base bill is estimated to have a discretionary cost of $446 million over the next 5 years. And the manager's amendment, by undoing the anti-fee diversion language, eliminates a procedure that would have decreased the budget deficit by $717 million over 5 years. And so the net result is that the manager's amendment will leave us with a bill that increases discretionary costs by almost $500 million over 5 years. This, of course, is a violation of the cut-go rules adopted by our new majority on the first day of this Congress. Beyond this concern, of course, in my view, the most important reform Congress could enact would be to prohibit patent fee diversion to help eliminate the Patent and Trademark Office's 700,000 application backlog. Unfortunately, as a result of last night's manager's amendment, this provision has been removed from the bill, replaced by what I view as a codification of the status quo that has permitted nearly $1 billion in fees to be diverted from the Patent and Trademark Office over the last decade. And if we are serious about patent reform, we need to end fee diversion once and for all, and unfortunately the manager's amendment doesn't do it. There are some other relatively important points that I would make, but that's my biggest contention. And I want to say to you, Mr. Chairman, that had I been supporting this bill, I would have withdrawn my support with this new manager's amendment. And so I will submit the rest of my statement and subject myself to your examination.
Mr. Conyers, and we always appreciate your thoughtful remarks before the Rules Committee and on the House floor as well. And you've raised some important issues. We're going to go back to questioning, and if Mr. Smith wants to respond to any of the things that have been said. Ms. Fox?
I don't have any questions, Mr. Chairman. Thank you.
Govern.
I have one question in light of Mr. Conyers' testimony. Mr. Smith, are you going to ask this committee for a waiver on the cut-go provision?
The quick answer is yes. The original bill had mandatory spending. We had to avoid that and go to discretionary spending.
Well, that's what we got to waive the cut-go provision. Okay, thank you.
If the gentleman would yield,
yield.
let me just yield to say that basically the modification that this would be making is would be taking it from mandatory to empowering the first branch of government, the House of Representatives, to deal with spending through the appropriations process. So I just wanted to clarify that it's actually enhancing the ability of.
You're going to have to waive.
I thank my friend for yielding.
But you're going to have to waive your own rules to move this forward. Thank you. You back,
Mr. Bishop, Mr. Hastings, Mr. Nugent, Mr. Polis.
I was hoping this is obviously we just all saw this, for the first time just a little bit before this meeting. But if you could explain a little bit about the new fee mechanism and how this fund works within appropriations. From my own perspective, I'm very interested in building the capacity at the Patent and Trademark Office and allowing them to be able to deploy their fees. And just some question about exactly to what extent this mechanism would do that versus still allow discretion for Appropriations Committee and Congress to use the money elsewhere.
Right. As the members may know, there was some original objection by members of the Appropriations Committee to our having a clean prohibition of fee diversion. So we have been working with them on a compromise. Mr. Polish, you just asked about the compromise, and basically and essentially it's that we are still setting aside the fees that the PTO receives in a separate fund. That fund will be controlled by the Appropriations Committee, but it's with the understanding that those funds can only be used for the Patent and Trademark Office. So the Appropriations Committee will still have oversight, still have control over the money, but we also have every assurance that the money will go to the Patent and Trademark Office, which they obviously need.
But at the discretion of the committee members, as ratified by the full House, they could, in fact, not appropriate those funds or use them for some other purpose?
It is my understanding that the agreement says that they cannot be used for any other purpose beside the PTO.
Is this a side agreement, or is this an actual piece of the amendment?
No, it's in the language as I understand it. We'll get you a copy of the language.
Thank you.
Very much. Mr. Scott. Gentlemen, thank you very much for being here. We appreciate it and look forward to consideration of this measure on the floor. Next, I'd like to take a panel led by Mr. Sensenbrenner, Ms. Lofgren, and Mr. Watt, the remaining three members of the Committee on the Judiciary. And so let me say to the three of you, without objection, your prepared statement will appear in the record, and we welcome your summary. So, Mr. Sensenbrenner, please proceed. Ms. Lofgren and Mr. Watt. Mr. Watt, we'll look forward to your testimony as well. Mr. Watt, are you going to join us here at the table?
Yeah.
Okay.
I need to clarify something.
Okay, good. Mr. Sensenbrenner.
Thank you very much, Mr. Chairman. I have submitted an amendment which I would like to have made in order, which strikes Section 3, which creates the first-to-file patent system. The sponsors of the amendment say that we should harmonize our patent procedure with other countries' first-to-file systems. Unfortunately, the Constitution and previous Supreme Court decisions make it quite clear that the patent attaches to the inventor when he invents it, and the filing and the issuance of the patent by the Patent Office only protects it. I have submitted a whole lot of Supreme Court decisions coming from the early days of the Republic to the present Supreme Court that says that the Constitution does not allow Congress to restrict a patent from someone who does not invent it. And I'm afraid that having the first-to-file system is going to bring a lot more premature patent applications, which will overburden the Patent Office even more than it is at the present time, and furthermore give our industrial competitors like the Chinese an opportunity to see what is in the mill in the United States, because as soon as the patent application is filed, it becomes a matter of public record. The first to invent standard has remained the accepted patent standard under the Constitution for over 200 years, and in my opinion, it should not be changed. And at the time of the framing of the Constitution, the common understanding of an inventor was the same as it is today, one who produces something new, a deviser of something not known before. And only the first inventor can discover something that is not known before. The only real experience in another country on this policy change and how it would affect U.S. inventive activity was a similar policy change that took place in Canada in 1989. An adoption of the first-to-file rule there did not induce additional R&D efforts made by Canadian inventors, and nor did it have such a policy change have the effects on Canada's overall inventive output, whether measured as patenting at home or abroad. I think this policy change is very unfavorable to independent inventors and small businesses, and for that reason it should be stricken. And thank you.
Thank you very much, Mr. Sensenbrenner. Ms. Loeffler.
Mr. Chairman, I have an amendment that I would ask be made in order. It's a simple clarification of Section 3 of the bill, which transitions us to a first inventor to file system. It would ensure the continued effectiveness of what's known as the grace period, which is a critical legal protection for inventors in the patent system. Under the law, our current law and the new one, an idea must be new, useful, and non-obvious in order to receive patent protection. And that's evaluated in terms of what exists prior, known as prior art. If an idea already exists in prior art, it can't be patented. And under current law, a variety of different things create prior art, such as descriptions of an idea in previous patents, printed publications, as well as public uses or sales. However, current law also has what's known as a grace period, which provides 1 year for an inventor to file a patent application after certain activities that would otherwise create patent-defeating prior art. So, for example, if an inventor publishes an article announcing a new invention, he or she has 1 year to file a patent application for it. Without the grace period, this publication would immediately defeat a patent application from day one. This grace period is a unique feature of U.S. patent law. It preserves a balance between an efficient system and the practicalities of developing and launching new enterprises. The director of the PTO, David Capos, refers to the U.S. grace period as the, quote, gold standard of best practices, unquote. In implementing the first inventor-to-file system in the U.S., however, this bill does not retain a sufficient grace period. A variety of stakeholders have expressed great concern that the revised grace period will not extend to everything that will otherwise qualify as prior art. While those terms remain in the definition of prior art, the new grace period as defined in the amendment would protect, and I quote, only disclosures. Various law professors, patent lawyers, and private individual inventors have expressed great concern to me about this, and we have worked with inventors, law professors, and others to clarify this. In particular, this amendment would ensure that public uses, sales, and offers for sales are covered by the grace period as they are today, regardless of how any other ambiguities are worked out by the courts. As far as I've heard, everyone agrees with the intent, including the sponsors and the Senate companion, and in fact, in a colloquy on the Senate floor between Senator Leahy and Senator Hatch, they really discussed the need to provide for this grace period and the full panoply of prior art. Unfortunately, as I've noted, the plain language of the statute doesn't really reflect the current state of play, and it's important that the ambiguities be clarified. There was a provision to attempt to clarify this measure during the committee markup. There was grave concern expressed by many sectors about the language in that amendment and how it would upset the meaning of prior art. And at my request, the committee voted unanimously to remove that section. The chairman pledged to work with me between committee markup and the floor to get new language. However, this amendment has not been included in the manager's amendment, and as the members of the committee are no doubt aware, the transition to first inventor to file has provoked grave anxiety among many, especially private independent inventors and the venture capitalists who fund them. This amendment will resolve many of those anxieties if it is adopted, and therefore I would urge that it be made in order. Thank you.
Thank you, Mr. Chairman. I'd like to thank both of you all for being here. Mr. Sensenbrenner, I note that the bill passed the Senate 95-5, and I'm just wondering if anyone made the argument that you are making about the bill over in the Senate.
Well, let me say that, mentally I kind of strictly follow the rules that nothing that happens in the other body should be discussed here. So I really can't answer the question. The fact is that there is a significant constitutional problem with first to invent and first to file. And I didn't give a string of Supreme Court decisions that start in 1813 and end up with Stanford versus Roche that was decided by the court earlier this month. And that is that if a person is first to invent and somebody else claims to be an inventor and files, then you're going to end up seeing this provision, I think, being held unconstitutional. And we all took an oath to uphold the Constitution, and I'm convinced that the language in Section 3 of the bill is going to cause grave constitutional difficulties that will end up in the Supreme Court like 5 years from now, and the best way to eliminate that problem is to strike Section 3 with my amendment.
Thank you both. I have no further questions, Mr. Chairman.
Yeah, this question for Ms. Lofgren. So when I talk to many who are involved with advocating the change, and of course talking about the one-year grace period, the response is typically that don't worry, they still have the one-year grace period. And I think that the language that you're offered would make that clear. So are your concerns that in the current language of the bill, it's not explicit or clear about the one-year grace period?
Well, in fact, the plain language refers to disclosures, which is far narrower than prior art is currently construed by the courts under the grace period that currently exists. Now, the argument could be that the courts will continue to interpret the law as it is today, but I think the private inventors and the venture capitalists who support them would like some clarity in the language itself. And there was a colloquy, as I mentioned, in the Senate trying to make it clear that there was to be no change. But in fact, I think the amendment actually makes this worse than the manager's amendment. And if I were starting a new venture, I would want the clarity that this amendment provides. I understand that Mr. Sensenbrenner's concern is farther than mine, but should there not be clarity on this point, I think many who supported first to file would have to rethink that position.
Thank you. Yield back.
Thank you.
Thank you, Mr. Chairman.
Next, I'd like to have a panel of members to include. I saw Ms. Jackson Lee here. She was right at the door. So Ms. Jackson Lee, Mr. Rohrabacher, Mr. Manzullo, Mr. Terry, and Mr. Boren. So please come forward. And Ms. Baldwin, sorry, please come forward. And without objection, your prepared remarks will appear in the record in their entirety. Why don't, and is Ms. Jackson Lee going to testify, or yeah, Ms. Jackson Lee, would you like to testify? Okay, please come forward. And let's begin with Ms. Baldwin.
Thank you, Mr. Chairman. I urge the Rules Committee to make in order the Baldwin-Sensenbrenner amendment that strikes Section 5 of the American Invents Act. Section 5 expands the prior user rights defense from its present narrow scope to broadly apply to all patents with minimal exceptions. As we work to rebuild our economy, Congress should do all that it can to foster small business innovation and investment. I believe Section 5 will do just the opposite. Expanding prior user rights will be disastrous for small American innovators as well as university researchers, and ultimately will slow job creation. Despite current challenges, the U.S. patent system remains the envy of the entire world. Since the founding of our nation, inventions have been awarded exclusive rights in exchange for public disclosure. This system also creates incentives for investing in new ideas, fostering new ways of thinking, and encouraging further advancement and disclosures. It promotes progress. If proponents of expanding prior user rights have their way with this legislation, it will give new rights to those who have previously developed and used the same process or product, even if they never publicly divulged their innovation and never applied for a patent. It will transform our patent system from one that values transparency to one that rewards secrecy. To understand why expanding prior user rights runs counter to the public interest, it is important to reiterate how critical exclusive rights are for inventions to gain marketplace value and acquire capital. For startups and small businesses, raising necessary capital is vital and it's challenging. The expansion of prior user rights would only make that task all the more difficult. Under the system proposed in the American Invents Act, inventors would have no way of determining whether anyone had previously developed and used the process or product that they were seeking to patent. In such a scenario, a patent might be valuable or relatively worthless. The inventor and potential investors would have no means of determining which was true. Mr. Chairman, I'd like to boast for a moment about a company called Stratitech. They are a fiercely innovative small business in Madison, Wisconsin, run by a top researcher at the University of Wisconsin who, through her research there, developed a living human skin substitute. This living skin is a groundbreaking treatment method that we hope will ultimately save the lives of American troops who have suffered burns while serving in Iraq and Afghanistan. The company was recently awarded $4 million to continue clinical trials of their tissue product. And what can save lives in a desert combat setting abroad will surely transform the way doctors save the lives of burn victims in hospitals around our country and around the world. I wonder if Stratitech would have been able to drive this phenomenal invention and life-saving technology as far as they have with a patent that provides only conditional exclusivity. Would investors have felt as secure advancing this technology in a system that is shrouded in secrecy? What if Stratitech's patent was subject to the claims of an unlimited number of people or companies that could later claim prior use? If we let Section 5 stand, it is unclear to me whether a similar company would ever secure the funding that they need to grow. It is clear to me that expanding prior user rights will stifle scientific progress at our leading universities, resulting in diminished investment, fewer products being brought to market, greater threats of intellectual property theft, and increased litigation. It is not surprising that many of our nation's leading universities, as well as leading innovators and business voices across the country, oppose Section 5 in this underlying bill. Mr. Chairman, during the past 6 years, the House has stood firm against special interests that have sought to expand prior user rights. Indeed, Supporting my amendment to strike Section 5 will conform the bill before us to the patent reform legislation passed by the U.S. House of Representatives on September 7, 2007, as well as Senate 23, the Senate companion legislation to the America Invents Act, as passed by the Senate in March of 2011. Section 5's expansions of prior user rights is bad for researchers, small business innovators, and patent holders. Instead, I support sound patent reforms that will provide innovators and investors with greater confidence, will fully fund the Patent Office to address the inexcusable backlog of patent applications, and expand opportunities for our brightest minds and most innovative businesses to transform ideas into new products and create jobs. I urge my colleagues on the Rules Committee to rule the Baldwin-Sensenbrenner amendment in order and ensure our attention remains focused on preserving and enhancing opportunities for American innovation and
Thank
jobs.
you very much, Ms. Baldwin. I'd like to go to Ms. Jackson Lee, as she's a member of the committee. Please, again, any prepared remarks that you have will appear in the record in their entirety, and we would welcome your summary.
Thank you very much, Mr. Chairman. I do want to acknowledge to the Rules Committee that my plane was late, and I did miss the presentation on H.R. 2021 and would only ask consideration of the amendments submitted, and thank the committee for its generosity and its attention. I happen to be a supporter of this legislation, and I'm excited about the opportunity for America to move forward in protecting its genius and the opportunities that we have. But I'm also very sensitive to the concerns that have been expressed by many of my colleagues. And, Mr. Chairman, I would hope that we might have a vigorous opportunity even for an open rule, because this is so much a part of the early underpinnings of the Constitution, and that is to protect the genius of America. The Founding Fathers were wise in their intent and had a vision that they wanted America to be at the cutting edge of research and invention and being part of the change maker for the world, making life better for not only Americans but the world. My First Amendment, number 26, amends the definition of small entities, and the gist of it is to include language that ensures that minority-owned and women-owned businesses are included. And Second Amendment, number 22, much like my First Amendment, includes minority-owned and women-owned businesses in the definition of micro-entity for the purposes of receiving the fee discounts afforded to these types of entities. I am now aware of the manager's amendment that has recrafted through a bipartisan compromise of how the fees, the user fees, should be used in order to encourage small businesses to be actively engaged in invention. I would like to suggest that those amendments be accepted. The U.S. Department of Commerce defines small businesses as a business which employs less than 500 employees. And all of us collectively speak about the value of small businesses. And I will not spend time but ask my colleagues to allow me to submit the rest of my commentary into the record. Amendment 29, HBCUs and Hispanic serving institutions. My amendment simply ensures that the intended goal of the language in this bill is actually achieved, that all colleges and universities, including historically black colleges, universities, and Hispanic serving institutions, receive fee discounts to keep the patent system accessible. Why do I have this language? Because I think it is very important to have a clarification so that these colleges that have particular use can be included, and particularly because of the vulnerable populations that many of them serve. To my amendment number 27, I'm offering up this amendment that expresses a sense of Congress that the patent system should promote industries to continue to develop new technologies that spur growth and create jobs across the country, which includes protecting the rights of small businesses and inventors from predatory behavior that could result in the cutting off of innovation. I think this is an appropriate bipartisan assessment of what we heard in the Judiciary Committee about the importance of ensuring that nothing that this bill does stifles innovation and creativity. This is amendment number 27. Several studies, including those by the National Academy of Sciences and Federal Trade Commission, recommended the reform of the patent system to address what they thought were deficiencies in how patents are currently used. I believe it is important that we ensure that our small businesses, again, are actively engaged in this process. My amendment number 23 extends the grace period for small businesses from 1 year to 18 months. This is the amendment. The amendment addresses a section of this bill which deals with the disclosure period, also known as the grace period. And I believe that because small businesses are most vulnerable because of their size, that they would benefit from an extension of time from 1 year to 18 months. When small businesses are attempting to develop an innovation, oftentimes it's necessary for them to make disclosures to outside entities because due to a lack of resources, they need to outsource the effort needed to bring an invention to market. For small businesses outsourcing their development, the 1 year grace period may not be an adequate period of time. Again, I believe this bill has the potential to creating jobs, and I think it's very important that we allow small businesses a greater latitude. Amendment number 25 is amendment that I believe reflects some of the consternation that has been heard. And as I said, I am supportive of this bill, but this amendment proposes for the sunsetting. I propose that the sunset would make this particular provision 5 years. This is the provision that targets a specific type of patent, is intended to iron out the inconsistency in the issuance of these types of patents and the many different rulings that flow from a mountain of litigation. And so I would like to change the sunset time from 10 years to 5 years. And I believe that this would help us assure that we had a good overview. Amendment number 24, requiring departmental determination that there is no unlawful taking of property. My amendment requires the director of the U.S. Patent and Trademark Office, because there's been a lot of discussion about the way we've crafted the bill, that there is a taking of property. I would make the argument that that is not the case, but I would offer an amendment that would ask the director of the U.S. Patent and Trademark Office within a year of enactment of this bill to make a determination whether the provision of this section could create a condition that could be considered an unlawful taking of property under the Takings Clause found in the Fifth Amendment of the Constitution. The director would need to report to Congress the underlying reasoning for his or her determination. I believe this is protection that is needed, and I think it does not do damage to the bill, and I think that we should be open about our overt support for the due process and that we do not have the unlawful taking of property. Final amendment number 28, my amendment is simple. It states that it is the sense of Congress that none of the provisions of this bill should constitute an unconstitutional taking of property under the Fifth Amendment of the Constitution. This has been a bill that's been long in coming. It has its origins from the very original responsibilities of this government, and I believe that we would do well to add this language to the legislation that would give comfort to many of those who are very concerned. Some comfort. I certainly don't believe that it would answer everyone's concern, but I ask consideration of these amendments.
Thank you very much, Mr. Excellent. Let's go to Mr. Mazzullo.
Thank you, Mr. Chairman. I would join in. Phil, could you give me some water over here, please? Thank you. I would join with Congresswoman Jackson Lee in hoping that this would be an open rule. I've been here for 19 years. I know of no bill that is more seismic to the American system of invention and manufacturing, where I spend most of my time, than this particular bill. It deserves to be fully vetted over a prolonged period of time in Congress so that it will be open rule. People can join in the conversation and offer whatever amendments they want. I ask for your support to allow the House to debate my amendment as revised to the American Invents Act to eliminate the provision in the bill that allows the director of the U.S. Patent and Trademark Office to set fees. There are a lot of problems with this bill, such as now adding a seventh layer of appeals. You can imagine what that will do to the little guy. However, I'm particularly concerned about Section 10 of this bill because it unravels the compromise on fees that I personally made back in 2004 when I chaired the Small Business Committee. In return for supporting higher fees with a reduced rate structure for small businesses and microentities, the provision allowing the PTO director to set fees was stricken. That was in 2004. This new bill abrogates that hard-won compromise. In fact, as part of that, that's when Congress allowed the PTO to outsource claims examination. And I'm the one that put the cap on each claim examination to be no more than $500 per claim per examination, so the little guy wouldn't get squeezed out by a huge bill coming from some outside entity. I do not believe it's wise for the legislative branch to give up more of its power and authority to the executive branch. This is not what the Founding Fathers envisioned. I know it's inconvenient to have Congress set fees, but we can't have an agency acting autonomously as its own empire, particularly of an agency that implements one of the specified enumerated powers of the Constitution. When I chaired the Small Business Committee, I continued the tradition of preventing the SBA from unilaterally being able to set fees to whatever level they sought. I don't see why we have to do this with the PTO. Well, Section 11 of the bill provides a good patent fee structure. Section 10, however, would allow the PTO director to proceed with the administrative process to eviscerate Section 11 and set whatever fees he may want. We could have a new fee structure in place within 5 months after enactment of this bill. And while I appreciate the 6-year sunset clause in Section 10, that could be easily extended indefinitely as some part of some must-pass bill down the road. There was a quoting from the Patent Reform White Paper from the U.S. Department of Commerce filed April of 2010. The U.S. PTO indicated that if it were given fee-setting authority, it intends to increase upfront fee share. Despite its lack of expertise for determining the adverse economic effects of such temporal costs, shifts on patentees, and the innovation to the economy. In other words, to cut back on the number of patents that will be filed, the PTO has stated several times that it will simply raise rates, raise the filing fees. And you can imagine what this would do to the little guy. The revised Manzullo Amendment retains the extra $400 fee for those inventors who do not file their patent applications electronically. With this change and the revisions to the Manager's Amendment, the CBO now concludes my amendment will no longer increase the costs relative to the underlying bill. Thus, the Manzullo Amendment has no budgetary implications and does not violate any rule of the House. The U.S. PTO has an inherent conflict of interest if given the power to set fees. The agency has said, as I just stated, on numerous occasions, going back as far as 1928 to as recently as last year, that they seek higher fees as a tool to help the PTO manage their caseload. Translated into plain English, this means they seek to lower the number of incoming applications through a higher fee structure. This is unconscionable, especially for a right that's protected by the Constitution. We should not stop innovation or discourage inventing just because the PTO has a large volume of applications. Already, fees are too high. We can't have fees go on a course where they could total in the tens of thousands of dollars. The key is to allow the PTO to retain its current revenue stream and not have the patent fee revenue siphoned off to fund other aspects of the federal government. That's why I hope you would also make the Conyers-Sensenbrenner-Manzullo Amendment in order. This would allow the PTO to process patent applications and other administrative matters in a timely manner. The PTO is expert at determining whether or not a particular widget is patentable. The PTO does not have the expertise to set fees and has a motive to limit income applications by raising fees. Increasing fees could also discourage an inventor from benefiting from the full term of the patent if the inventor believes the annual cost is too high to maintain the patent. My brother had a trademark in his little restaurant with 13 tables, just a little bitty guy, on a sandwich or a dish that he had at the restaurant. The PTO wanted just to file a paper, just to renew that, $500. Just $500. I mean, already. I mean, these are, Chairman, these are little bitty people. My brother with a high school degree in the family restaurant for 41 years developed this trademark, had to pay an additional $500 to keep the trademark going. He said, Don, it's not worth it, especially because it's protected by the Constitution. He has a constitutional right to that. And so what will happen now in this proposed legislation, the PTO can go in there and he can squeeze how many Frankie Manzulos from exercising their entrepreneurial spirit. And maybe it's all about him. It's always been about him because he's my only brother and he's an inventor himself. I would ask that that compounding the problem is the PTO has indicated in recent years that if given fee-setting authority, it intends to increase the upfront fee share. This is already a promise from the PTO. They promise you give them the authority to raise fees, they're going to raise fees and make them so high, that's their solution to cutting back on the patent applications. That would be a very, very bad day for America. And I would ask that you make this amendment in order.
Thank you very much, Mr. Manzullo. Let me say that, again, as I did at the outset before most of you were here, I'm going to encourage this committee to make in order as many amendments as possible. We had 33 amendments. Take into consideration those that were withdrawn, and I want to make sure that every issue area is addressed as we proceed with the debate. And so I think it's safe to say that the issues of concern that all of you have raised here, I'm going to encourage the committee to make amendments in order. They may not be your particular amendment because we've had some duplication of amendments, but I just wanted to say that as people proceed with their testimony, to say that I'm going to encourage the committee to make amendments in order. And Mr. Rohrabacher, yours is one of them. You might keep that in mind as you proceed with your testimony and in light of the fact that we have votes on the House floor.
Oh, yes.
So I don't know if I need to be any more subtle than that, but thank you.
Well, I would urge you, Mr. Chairman, to make all of the amendments, except ones that are totally duplicative, all of them. Just have an open rule, and those that you find duplicative, that's your job. That's what you're here to find out.
Well, as I said, that's my intention to try and do, and yours is one of them. So.
All right, thank you, and I would urge you to make sure that the Rohrabacher capture a moment.
I see Ms. Capter here as well, and she's in support of making the amendment in order. So
I would hope that you would make our amendment.
I'm hoping the committee will do so as well.
In order, and lots been said about why this bill overall should be supported, and most of the time you hear all about this big backlog of work that's in the patent office, and patent office needs to be more efficient, and how people are waiting for this. Well, of course, all of those problems can be solved without actually handling some of the major policy things that have always been thrown into the patent bill. Because the purpose of the patent bill, and many of the patent bills in the past, has been basically not to cure those problems, but instead to basically change patent law in America, and yes, harmonize it with the rest of the world. That harmonization is the basis of a lot of our disagreements, and a lot of our amendments are based on the fact that that creates new problems, especially for the little guy, especially for the small inventor trying to harmonize with the rest of the world. And that's true especially in the area that Ms. Capter and I have focused on, which deals directly with the burden that's created to small inventors and small businessmen by the expansion of the post-grant reviews and reexamination on individual inventors and small businesses by this bill. And our amendment would say, okay, you want to have increased reexamination and post-grant reviews? Yes, let's let's basically eliminate that requirement for small businesses and inventors, small businesses with fewer than 100 employees. A post-grant reexamination takes place after an inventor's application is approved and the patent is granted. We're always talking about something that after the patent is granted. And to receive a patent, an inventor must achieve a very high burden of proof. By allowing a post-grant process for small business and individual inventors, it adds dramatically to the cost, and especially if some very powerful interests decide to intervene and exploit this new burden that the small inventor and small businessmen have to put up with in order to get their patent. Post-grant reexaminations can take years and cost hundreds of thousands of dollars, even millions of dollars, which is a significant burden on these small guys, although the big guys, they understand that, and in fact they may be using that as a tool to pressure small inventors to give up their inventions at bargain basement prices. Even after successfully defending a patent through the post-grant examination, an inventor can be sued, by the way, so can be sued in federal court. So when we're talking about eliminating this post-grant examination and getting rid of this new requirement for a new post-grant review, there's still a way of challenging the inventor. I mean, they can be taken to court. And so we're not just saying that once that patent is granted, if there's been a mistake made, there's no way to alleviate that problem. H.R. 1249 makes it easier than ever to tie up an inventor, however, in post-grant reexaminations, and thus adds an additional post-grant review process that, again, could even further the burden of these small guys who are usually the people who come up with the innovative ideas that change our society. In fact, let's note that Hoover Institute just did an incredible study of the patent bill and said that what this would do would be to give leverage to these big corporations who have created no jobs in the last 20 years at the expense of the small inventor and small corporations and startups who have created all the new jobs in the last 20 years. So this provision itself and some of the provisions of the rest of the bill are actually making it more difficult to create jobs by those who are the main job creators.
Well, thank you for that. Let me just say I read with great interest your piece in Politico this morning, the column that you wrote.
Okay,
and,
thank you.
Very much appreciate that.
Just very quickly, I'd say the Capter-Rohrabacher Amendment eliminates the burden on the individual inventor, small and businessman who has 100 or fewer employees, excluding them from this new post-grant review and the former post-grant review procedures.
I actually look forward to a debate and vote on the House floor on it.
Thank you very much.
Thank you very much. Mr. Terry.
Thank you, Mr. Chairman. Hoping that listening to your dicta will be rewarded. I am here to request my amendment be ruled in order that strikes the first-to-file provisions. There's lengthy discussions, including recent comments and dicta by Chief Justice Roberts that questions the constitutionality of going to a first-to-file from inventor-based. Let's have that debate. Thank you.
As you know, Mr. Sensenbrenner has offered a very similar amendment to that, and I do very much want the issue to be considered. Mr. Boren.
I'm going to go along the same lines as my friend, Mr. Terry. You said to be brief. I have a long statement. I'm not going to read it.
Without objection, it'll appear in the record.
Just my amendment is bipartisan with Mr. Schock. It repeals Section 18. It's a small business issue, and we would sure appreciate your
I'm hoping
consideration.
very much that this committee will make it in order. I'm going to encourage them to.
Thank you, Mr. Chairman.
I have no questions. Ms. Fox. No questions, Mr. McGovern. Without objection, Ms. Eshu's statement will appear in the record. Mr. Bishop. Mr. Hastings. Mr. Nugent, Mr. Polis.
Just want to thank Mr. Manzullo and Mr. Rohrbacher for requesting an open rule. We too hope that there will be a open rule for this bill. I think it'll give all of us a chance to work our ideas and improve the bill on the floor of the House, and I yield back.
Mr. Scott, Mr. Webster, thanks to all of you for being here, and we look forward to considering the bill on the floor. I see that Ms. Moore is here and Ms. Capter is here. I will say again, as I have before, as I see the two of you, I'm big fans of yours, and I hope very much that this committee doesn't object to my encouraging to make your amendments in order. So in light of that, if you'd like to offer any testimony, we'd certainly welcome you. Ms. Capter? Good, you bet. I see Mr. Conyers is as well, and Ms. Jackson-Lee, I guess, is here in support of her colleagues.
I certainly am, but I'm stepping away from the table with that.
That won't diminish the support, I'm sure. Ms. Moore.
Thank you, Mr. Chair, and I do appreciate all of the hard work that the committee does. And I have two amendments, and I would hope I do have testimony that I would ask for you to
Without
put into the
objection,
record.
the testimony will appear in its entirety in the record.
Thank you, sir.
Okay, thank you very much. Are there any other witnesses? I know we have votes on the House floor. We're going to recess the committee, and there is one jurisdictional issue that needs to be resolved, and I have gotten no staff indication as to when we might get that resolved, and so we're going to be in touch with you, and we will hope to reconvene the committee at some point. I can't say that it'll be done immediately after votes. So we've got votes going on downstairs, so the committee stands in recess subject to the call of the chair.
Yes, thank you. Oh, how nice. Okay. Yes, we are. God knows.
The Rules Committee will reconvene. We're here for further consideration of the rule that will allow us to take up on the floor the Jobs and Energy Permitting Act of 2012 and the America Invents Act. And the chair will be in receipt of a motion.
The committee report a rule for consideration of H.R. 2021 and H.R. 1249. The rule provides for consideration of H.R. 2021, the Jobs and Energy Permitting Act of 2011, under a structured process. The rule provides 1 hour of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce. The rule waives all points of order against consideration of H.R. 2021. The rule provides that H.R. 2021 shall be considered as read. The rule waives all points of order against provisions in H.R. 2021. The rule makes in order only those amendments to H.R. 2021 printed in Part A, the report accompanying the resolution. Each such amendment may only be offered only in the order printed in the report. May be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and opponent, shall not be subject to the amendment and shall not be subject to demand for division of the question. All points of order against this amendment printed in Part A of the report are waived. The rule provides one motion to recommit 2021 with or without instructions. The rule provides for consideration of 1249, the America Invents Act, under a structured process. The rule provides for 20 minutes of initial debate confined to the question of constitutionality of the bill, equally divided and controlled by Representative Smith of Texas and Representative Capter or their designees. The rule provides for 1 hour of general debate on the bill, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary. Waives all points of order against the consideration of H.R. 1249. The rule makes an order of the amendment in the nature of substitute recommended by the Committee on the Judiciary, now printed in the bill as an original bill for purposes of amendment, which shall be considered as read. The rule waives all points of orders against the committee amendment in the nature of a substitute. The rule makes in order only those amendments to H.R. 1249 printed in Part B of the Rules Committee report accompanying the resolution. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered to be read, shall be debatable for the time specified in the report, equally divided and controlled by a proponent and an opponent, shall not be subject to amendment, and shall not be subject to the demand for division of the question. All points of order against the amendments printed in Part B of the report accompanying the resolution are waived. The rule provides one motion to recommit H.R. 1249 with or without instruction.
You've heard the motion of the gentleman.
Finally,
oh,
Section
sorry.
3 of the rule provides...
I still heard it, even though it wasn't finished. But
The rule provides that upon receipt of the message from the Senate transmitting H.R. 1249 with the Senate amendment or amendments thereunto, it shall be, in order to consider in the House a single motion offered by the chair of the Committee on the Judiciary or his designee, that the House shall disagree to the Senate amendment or amendments and request or agree to a conference with the Senate thereon. All points of order against the motion are waived. The motion shall be debatable for 1 hour, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary.
so maybe we should establish the 5-minute rule for offering motions, at least. You've heard the motion of the gentleman. Let me say very briefly that as I'm looking through this list, you can see there are a number of bipartisan amendments, many more Democratic than Republican amendments made in order. Virtually every issue is addressed. The one thing that I would like to do is, after the testimony that was provided by Ms. Jackson-Lee, she has just requested the committee that we withdraw her amendment from the rule, and so without objection, Ms. Jackson-Lee's amendment is going to be withdrawn. Is there any objection?
No objection.
Okay, hearing none, it's so ordered. And in light of that, are there any amendments or?
There are. Thank you, Mr. Chair. I appreciate a lot of good amendments
Before you begin,
here.
let me just welcome Bob Slaughter back to the Rules Committee. It's always great to see him here.
Thank
He's
you
almost
for
a
that.
Lone Ranger out there.
Yeah,
Good to see you, Bob.
I appreciate it. He didn't come down much. I'm happy to have him here. I just want a personal concern for mine that Ms. Ashew's amendment, I'm not calling for any vote on it, that would have allowed people to litigate where they live and not have to have everybody come to the D.C. Circuit, was not made in order. And I do have an amendment. I have an amendment to the rule, move the committee grant H.R. 1249 and H.R. 2021, both open rule.
You've heard the motion of the gentlewoman. Any further discussion? If not, the vote occurs on the Slaughter amendment. Those in favor will say aye. Those opposed, no. Pin the chair, the noes have it. The noes have it. The motion is not agreed to. Are there further amendments?
Roll call, please.
Oh, you'd like a roll call. Clerk, call the roll.
Mr. Sessions? Ms. Fox?
No.
Ms. Fox, no. Mr. Bishop? No. Mr. Bishop, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Nugent? No. Mr. Nugent, no. Mr. Scott? No. Mr. Scott, no. Mr. Webster? No. Mr. Webster, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern? Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No. Clerk, report the total.
2 yeas, 7 nays.
And the amendment is not agreed to. Are there further amendments?
Yes, I have
Yes, Slaughter.
one more. Mr. Chairman, I see you are waiving cut-go for the manager's amendment. And as I expressed to Mr. Smith today, there's a real issue that I have with that. I don't think we should waive cut-go and move that we amend the rule to not include a waiver of Clause 10 of Rule 21.
You've heard the motion of the gentlewoman. Let me respond by saying this is merely a technical measure. I have a statement here that I'd like to share with my colleagues. We've had a discussion on this. The underlying bill from the Judiciary Committee violated the House rules by appropriating when it moved the patent fees from discretionary spending to mandatory spending. The manager's amendment, at the insistence of the leadership and this committee, fixes the Judiciary Committee's violation of the House rules, and we do so in a transparent way, not self-executing it in the rule, but including it instead in the manager's amendment. To get to the manager's amendment, it's necessary for this to take place. Again, it's a technical waiver to get to the vote on the manager's amendment, and compared with current law, the bill as amended by the manager's amendment will have no effect. This has no budget implications whatsoever. Chairman Ryan of the Budget Committee supports this solution because it keeps the spending on the discretionary side where it is subject to appropriation, budget enforcement, and oversight. So again, we are rectifying a move that the Committee on the Judiciary made to establish mandatory spending, which would not have allowed for adequate oversight. And so I think institutionally, the idea of making it clear that we want this authority and power to lie with the first branch of government is correct, and that's why this technical waiver is necessary. Mr. Hastings.
If you would just yield for a moment.
Sure, happy to yield.
You're prepared to vote to waive cut-go for a manager's amendment that was written sometime or somewhere, and some of us saw it for the first time. Now, I heard your explanation just then, and it would sound an awful lot like Congress speak to me, and I understand Congress speak. You would agree, would you not, that very occasionally, either in the majority or the minority, that
Excuse me, Ms. Waters, I just wanted to tell you that your amendment is being made in order in this bill here. I just wanted to tell you, your amendment's being made in order is what I was trying to tell you downstairs here. Yes. Oh, I know. That's quite all right. That's quite all right. That's quite all right. Oh, no.
They accuse you correctly, Mr.
We all
So here we got concern being voiced, and I'm making in order Waters amendments, Jackson Lee amendments, that since she's withdrawn.
All of that is deeply
Trying
appreciated.
to do everything we can to account. Mr. Polis's amendment is made in order under this measure.
I have an amendment that's made in order. And
Mr. Hastings has an amendment made in order.
Mr. Chairman, but the point that I'm trying to make is that when we do complain about backroom deals, that at least the word that you used in your explanation just a moment ago was this is extremely transparent. Well, I'll tell you what's transparent. Mr. Sensenbrenner and Mr. Conyers came in here with an amendment to put the committee's own patent office funding language back into the bill. So what you're comfortable doing, it appears, in the majority, and it's your prerogative, or bending over backwards to please your party, even if it means undoing the work of the Judiciary Committee. But when the Democratic ranking member, who is also a former chair of Judiciary, and the former Republican chair of Judiciary want to restore the bipartisan version, I might add, of the bill, you block it. And that leaves me pausing considerably at the process.
Right.
And I do accuse it of being backward.
Let me just say a couple of things. First, as you know, Mr. Conyers' amendment is being made in order to deal with the matter that was included at the committee level, and the manager's amendment seeks to strike. And so again, Mr. Conyers made that request, and we are complying with that. The amendment about which my friend is speaking is a further violation beyond cut-go, and we're not providing waivers for that. It's a Clause 5 violation, and so we are not going to provide waivers for that. And again, this matter is nothing but a technical matter. Doesn't impact the budget at all, no spending implications. And as the Budget Committee has stated, what this does is, and as I said earlier, it gives us the ability to do our job with discretionary spending. So I'm going to urge a no vote on the Slaughter amendment. Those in favor will say aye. Those opposed, no. Pay the chair, the noes have it. The noes have it.
May I have a roll call, please?
You already voted no. I heard you vote no.
I'm sorry. No, I wanted. I
was
really
gonna
wanted
announce
to
it as
stop
unanimous.
before we got to the end here. I was
Okay.
distracted a moment.
Okay. Clerk, call the roll.
But I have
The-
the SU amendment. We
Right,
wondered
what-
if we could get
Whoa. What's happening?
to replace. Oh, yeah.
Okay. Well, can we vote on?
We can vote.
You want a recorded vote?
Yes.
Okay. Clerk, call the roll.
Mr. Sessions. Ms. Fox. No. Ms. Fox, no. Mr. Bishop. Mr. Bishop, no. Mr. Woodall. Mr. Woodall, no. Mr. Nugent. Mr. Nugent, no. Mr. Scott. Mr. Scott, no. Mr. Webster. Mr. Webster, no. Ms. Slaughter.
Aye.
Ms. Slaughter, aye. Mr. McGovern. Mr. Hastings. Aye. Mr. Hastings, aye. Mr. Polis. Mr. Chairman.
No. Clerk, report the total.
2 yeas, 7 nays.
And the motion is not agreed to. The amendment's not agreed to. Excuse me. And Ms. Slaughter.
I wonder if I might offer Ms. Eshu's amendment, which simply protects local courts. Let me see if I can.
Right. You mentioned this D.C.
I
thing.
did, so that everything does not have to be litigated in the District of Columbia, but can be litigated locally.
Well, I understand and appreciate that, and apparently this is similar to the Jackson-Lee amendment, which has been withdrawn, and it does put us in a somewhat awkward position in light of the fact that it's been withdrawn by the author of the amendment that we did make an order. Ms. Eshu was not here, Ms. Jackson-Lee was here, and we chose to do that. And so it's been her request to withdraw the amendment, and we're in the midst of our markup now. Thank you. So the vote will occur on Ms. Slaughter's amendment. Those in favor will say aye. Those opposed, no. Pin the chair. The noes have it. The noes have it. The amendment is not agreed to. Excuse me? Oh, okay. Well, that wasn't made clear to me. Okay. So what we would like to do then is Ms. Eshu's amendment would be offered in place of Ms. Jackson-Lee's amendment. And so, in light of that, I'd like to ask unanimous consent that the committee accept Ms. Eshu's amendment in lieu of Ms. Jackson-Lee's amendment. Is there objection? Hearing.
Objection, Mr. Chairman, but we have not gotten into the vote, so I guess
Yeah. No, I absolutely. Without objection, it's so ordered. Okay. Any further amendments?
Yes.
Mr. Hastings.
Mr. Chairman, I don't intend to call for a vote on this amendment, and I did mean it just to pique the interest of members about how facetious it is that people would argue that these clean air provisions are not vital. So I do have an amendment to the rule, and I'll move the committee make in order and give the necessary waivers for the amendment, which would require the head of an entity, Shell Oil, for example, applying for the Clean Air Act permit to stand not more than 10 feet away from the primary exhaust of the outer continental shelf source for a period of not less than 25 minutes. And there'd be a hell of a lot less patents being sought if they had to do that. This is an awesome amount of pollution that we are circumventing. And I think Mr. Rush made the point during the testimony for one company, and I just for the life of me do not understand it. I understand all of the political flip-flap about the Environmental Protection Agency, but if you didn't have one, you'd have to invent one if it is that we're just going to let people run amok. I told the story, Mr. Chairman, before when I went to college in Nashville, Tennessee. I almost had to leave because of the pollution that was there at that time. I also lived, as did you, in California at a time. I remember awakening one morning and I literally could not open my eyes because the smog was so intense. And I informed my mother and father that I wasn't going to live in California after that period, and I didn't. My point being that these provisions, while some might consider them onerous, have provided for good health for individuals. And so I offer the amendment, and I will vote aye on it, but I will not ask for a roll call so as how not to cause none of y'all to have to stand 10 feet away from.
We very much appreciate that. And let me express my appreciation. I never thought there was a benefit to the air pollution problems that we had in Southern California, but by virtue of your move, I never had to face running for Congress in Los Angeles. So
it helped an awful lot.
Thank you very much for that. Vote occurs on the Hastings Amendment. Those in favor will say aye. Those opposed, no. Opinion chair, the noes have it. The noes have it. The motion not agreed to. Are there further amendments? If not, the vote occurs on the motion of the gentleman from Utah, Mr. Bishop. Those in favor will say aye. Those opposed, no. Opinion chair, the ayes have it. The ayes have it. The motion is agreed to. Clerk, call the roll.
Mr. Sessions. Ms. Fox. Aye. Ms. Fox, aye. Mr. Bishop. Mr. Bishop, aye. Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Nugent. Aye. Mr. Nugent, aye. Mr. Scott. Aye. Mr. Scott, aye. Mr. Webster. Mr. Webster, aye. Ms. Slaughter.
No.
Ms. Slaughter, no. Mr. McGovern. Mr. Hastings.
No.
Mr. Hastings, no. Mr. Polis. Mr. Chairman.
Aye. And the clerk will report the total.
7 yeas, 2 nays.
So the amendment, which was the rule, which includes amendments from Mr. Hastings, Mr. Polis. We've put the Eshoo amendment in now, which was opposed by the minority, will be managed by the gentleman from Florida, Mr. Nugent. And by Mr. Polis. And we are going to be meeting tomorrow, I guess, at 3 o'clock. Do you seek recognition? Just waving. Just waving. Okay, well, I'll wave back then. I'll wave right back to you. Thank you all. Yes. Yes. Well, we're scheduled to meet at 3 o'clock tomorrow, at which time we believe that we will consider a measure on Libya as well as the Department of Defense appropriations bill.
When will we be creating
We're working on it right now, and we want to have a number of measures considered as we proceed with the debate. We've been having discussions on it, and just as soon as we have it, we'll let you know. Okay. Thank you all very much for that objection. The committee stands adjourned.